A ruling handed down by the High Court in Johannesburg has now declared some parts of the Basic Conditions of Employment Act discriminatory. As part of the amendments, both mothers and fathers would be allowed to take parental leave and claim UIF during the time. Parliament has 2 years to remedy the provisions. Labour relations expert advocate Tertius Wessels joins us for this now. A very good evening to you, advocate. Good to have your time. At a very basic level with this sort of thing, I think it's always good to begin with an explanation of what the change, when it's finally official, will mean, especially in the case of fathers to newborns.
Good evening, Tembekile, and good evening to the viewers. I think what's important for us to understand is that historically the Basic Conditions of Employment Act had only made provision for mothers who gave birth to a child to be entitled to maternity leave to a period of 4 months. We have over the years seen some amendments to the Basic Conditions of Employment Act, which also introduced certain additional leave entitlements for the fathers of a newborn child, being parental leave, which was 10 days, and also provisions with regards to surrogacy and adoption leave. What this court ruling has ultimately done is to declare various of these provisions contained in the BCEA as unconstitutional. And the High Court has introduced immediate remedies for parents overall, regardless of the manner in which they become parents, whether or not the child is born of the mother or you become a parent via surrogacy or the adoption of a child younger than the age of 2 years. The High Court has now determined that the parents are entitled to 4 months parental leave. And whilst it's unpaid, they are entitled to claim UIF benefits during the course of this period. Obviously, if you are a single parent, you would be entitled to 4 months. But one of the things that the court has set out is that where there are 2 parents with a child, then they can decide amongst themselves how they would like to split that 4-month period.
And explain perhaps, if you can, advocate, why the element of a split has been introduced and how, in reality, that may be negotiated by the 2 parents. For example, are they employed perhaps in separate areas of employment? Would it work better, I don't know, in the final writing, if these are people who are in the same space, etc., employment-wise?
I think that for the immediate now, the discretion is still left up to Parliament in order to formalize these changes, hence the provision for the 2-year period. What we do need to understand is that ultimately the aim behind this 4-month parental leave is to ensure that the primary caregivers are able to look after the child. And depending on what the situation might be between 2 parents, there might exist a need for one person to go back immediately to work. If you take, for example, in this particular matter, the mother of the child was a business owner, and there was an immediate need for her to almost go back to workplace, where the father of the child would then be able to step in and fulfill that role as primary caregiver. However, the court has made a provision for the parents to make a split if they so wish to do.
And for the parents who are adopting, there is a provision or a technicality, shall I say, because that will have to do with the age of the child. If the child is older than 2 at the time of adoption, then a different rule would apply, correct?
That is correct, yes. So the provision for the 4 months only applies in circumstances where parents or people become parents of a child under the age of 2 years, and where they are adopting a child older than 2 years, then those provisions would not apply. It's almost similar to the provisions that we currently have, where only used to have, where the parents would be entitled to 10 weeks leave in circumstances of an adoption, yet where the child is older than 2 years, they do not become entitled to any leave benefit.
And I'm curious, advocate, about the feeling among labour, among employers about this, because we know that most companies, let's be honest, in this country, even with annual leave, like to stick to the bare minimum stipulations, and now you've got this change which ultimately will force them to have an employee, be it a mother, be it a father, away for this period.
You're definitely going to have mixed feelings amongst employers. The reality is that this ruling does affect businesses And many employers are going to have to immediately look into the manner in which their policies regulate leave within the workplace. And they're going to have to bear in mind that you now do have a situation where somebody that would ordinarily not be absent for an extended period of time as a result of the birth of the child may now also qualify for such extended leave. Other employers are welcoming this ruling, specifically in as far as it does away with the inequality and the infringement on dignity and certain stigmas that have historically existed in the workplace, especially if one looks at same-sex marriages or relationships. So many are welcoming this as a move in the right direction and saying it's about time that we actually acknowledge that mothers or birth mothers are not the only people that are primary carers for children.
Thank you so much for your time, Labour Relations expert, Advocate Tertius Wessels. Good to have your time.